Yes, hello, here we are again. My name is Evelien Bruggeman. I'm a professor of construction law at the Technical University in Delft. And you're now watching the 5th video on private law. And I'm going to talk in this video and the next video about procurement law. So that's a whole different ballgame. This video will be about the principles, just a starting point of procurement law, because it's, I think, important to know that in the first video, I talked about the freedom of contract and the freedom to enter into a contract with whomever you liked. That's different when we're talking about procurement law, because for government bodies, there are restrictions to the freedom of contract. They need to comply with the rules of procurement law for several reasons, and I will discuss those reasons here in this video, and I will elaborate on this subject more in the next video, in the upcoming video, the last one, number 6. So for now, this is what we're going to talk about. Here are my contact details again. And of course, you need to study the book. And the book is mostly on construction contracts. There's one chapter on procurement law. It is not very elaborate, so it should be really easy to comprehend. But nonetheless, procurement law is a very important subject for construction law, for construction contracts, because most of the assignments of the projects are government projects by government bodies. So most of the time, a lot of the time, you will be dealing with procurement law, whether or not you're a client, the government body, or you are a contractor. So be aware, it's an important part. And what I wrote down in the chapter in the book is just, again, touching the surface, because there are entire libraries dedicated to procurement law. And when you stumble upon a problem regarding procurement procedure, just know that you should contact a lawyer, because this is a really specialistic field of law. So study the book, study the slides, listen to my talk, and I will talk you through it right now and just point out the essentials, so you know what to look for, you know what to deal with, what you're dealing with. So I will discuss what procurement law, or what procurement is, and therefore what procurement law is all about. I will discuss the objectives and the principles of procurement law, and especially because it's easier to understand if you know what the objectives are and what the principles of procurement law are. You know what to look for when there's a problem during a procedure, either on the side of the client when you're working for a client, or either on the side of the contractor. I will tell a bit about EU law, because procurement law stems from EU law. I will talk about terminology and what a contracting authority is, and I will talk a bit about the contracts covered by law of procurement. And then in the next video, I will talk more on the procedures, on qualifications and invitations to tender, and award criteria and selection criteria, and maybe a small bit on disputes and remedies. So for now, the basics in this video. So what is procurement? It's the purchasing of goods and services from an outside body by the government. And during this procedure, because procurement is about the procedure of purchasing goods and services, the contract needs to be specified and the procedure needs to be specified. There needs to be some sort of transparency beforehand, before we start a procurement procedure. But I will elaborate on that more. For now, you need to know procurement. When we talk about procurement and procurement law, we specifically are talking about the purchasing of goods and services by the government. That's important to know. And what is procurement law? Procurement law covers the process of leading up to the award of the project, the contract. It's better to say the contract, leading up to the award of the contract and the conclusion of the contract. So procurement law is about the process. It states all the important requirements for a procurement process to make sure that in the end we can award the contract according to the rules of procurement law, and we can conclude the contract. So why is this important, and why are those principles? Why is procurement important? Why do we need? Why do government bodies need to comply with the rules of procurement law when they are looking for a contracting party? And the essence of procurement is basically equality. We want, in a democratic state we live in, we find it important that the government offers equal chances to all people who are able to enter into a contract with them. And if they just would be handing over jobs to the people they like or to their friends, that would not be given equal chance to all the people. We want the government to be fair, to be transparent, and to treat us equally all. So that's the essence of procurement law. That's why we have such elaborate procedures, because we want to be fair and be treated equal. And here you see one of the recitals of the EU directive, because as I said, procurement law stems from European law. And here you learn something about procurement law. So the union rules on public procurement are not intended to cover all forms of disbursement of public funds, but only those aimed at the acquisition of works, supplies, or services for considerations by means of a public contract. So we're dealing with public contracts handed out by the government, and it's only about the acquisition of works, supplies, and services. And of course, when you're dealing with construction and construction law, it's works we're dealing with, and that's why we're here talking about procurement law. So procurement law is governed by European law, and there's this directive on procurement law 24 from 2014, which is on the procurement of works. And there was a previous directive from 2004, and it's the new directive of 2014 is repealing the old one. In essence, procurement law is covering one of the basic aims of the European Union, because the European Union wants to eliminate barriers, and they want to make sure that there's freedom of movement of people and of goods and services. And by making those rules on procurement, we are making sure that there's freedom of movement and freedom for the people, movement of people and of goods and services, and also works. So because of the of applying the same rules in every country in the European Union, we offer all companies, all parties here in the European Union the same chances to get a contract from the government. And we are, by using those procurement laws and principles, eliminating barriers. So it's at the essence of European law. It's the essence of European law, and it's at the center of European law, procurement law. And by removing the barriers, we improve economic welfare of all member states. That's one of the objectives of the EU, of course. So we can spread the wealth throughout. So this also says something about procurement law. This is again a recital, so it's the starting point of the directive, that the award of a contract has to comply with the principles of the foundations of the European Union, and in particular to, as I already stated in the previous slide, the free movement of goods, freedom of establishment, and the freedom to provide services, as well as the principles deriving therefrom, such as equal treatment, non-discrimination, mutual recognition, proportionality, and transparency. And here you have it. Those are the principles of procurement law. And throughout the entire directive, which is really elaborate. And throughout the implementation of the directive into the Procurement Act here in the Netherlands, but also in other EU countries, you can find those principles in the separate provisions. So equal treatment, non-discrimination, proportionality, transparency, it's all there. And it's the basis of the entire Procurement Act and procurement law in general. And even if you live in Switzerland and you don't adhere to the directives of the EU, those principles are at the heart of procurement law because they're also part of the WHO agreement, which is a worldwide agreement, and Switzerland is part of this WHO agreement. So the principles of procurement law of non-discrimination, proportionality, equal treatment, transparency, and mutual recognition, those are worldwide accepted principles and very important, therefore. So here you can see the principles not only stated in the recital, but also in Article 18 of the directive, and they are implemented also in the Dutch Procurement Act. That's not a given, that if there are principles in the directive that they should be implemented in the national acts, but in the Netherlands we have implemented those principles into the national act. So equal treatment and non-discrimination, everybody is treated equally. We cannot discriminate on the basis of nationalities, so we cannot decide, for example, in the Netherlands that we only want Dutch suppliers. No, we cannot exclude German or Belgian or even Italian or whatever suppliers. Everybody must be treated equally under those directives and principles. And the demands we put in our tenders, in our requirements, must be proportionate in order to not exclude people or parties or smaller companies who might not be able to obtain certain contracts when the demands are too demanding, I would say. So proportionality is also an important aspect of the principles, and the same goes for transparency. So you need to be transparent on your full requirements and purposes, but also all parties involved and everybody should know what you're talking about. So as a result, there's fair and equal chances for everybody. And I need to say a little bit about Chinese walls. That's, for example, why we exclude consultants, engineers who have been involved in the design phase or in a phase leading up to a procurement. That's maybe better to say that people, whether it are contractors or architects, doesn't matter if they have been involved in the preparations of a procurement process. They have more knowledge and an advantage compared to people who are just trying to enter into a contract on the same subject. So they are excluded from certain procedures just because they don't offer the equal chance to other parties involved. And that's why we invented those Chinese walls, to make sure that everybody has an equal chance. So as said, it stems from European law, procurement law, but we have implemented those directives into the Procurement Act in the Netherlands, and the same goes for all European countries except for Switzerland, which is not a European Union country, but they have the WHO agreement. And there is the Public Procurement Act here in the Netherlands, but we also have a Public Procurement Decree, which goes into more detail on certain things. And the Works Procurement Regulations, the same goes for this set of regulations. And then we have something really special here in the Netherlands, and that's the Proportionality Guide. And that's part of our system here in the Netherlands. And in the proportionality guide, examples are given, explanations are given on proportionality. So if we look at the principle of proportionality as laid down in the procurement directives and the Procurement Act, it is further explained and made explicit in the proportionality guide. And this is fairly unique in Europe, that we have a proportionality guide which elaborates on the principle of proportionality and gives government agencies guidelines on how to act in specific circumstances to be in accordance with the proportionality principle. And you are lucky. Last year, the former director of the Dutch Institute of Construction Law made it her point to translate our Dutch proportionality guide into English. So this can be a guide for all countries in Europe to learn more about the proportionality principle, and you can download it for free here on the website of the Institute of Construction Law. So I can really recommend to give you a sense of the principle of proportionality and what we actually mean by it in very specific situations. So a little bit more on terminology. So we talk, when we're talking about procurement law, we're not talking about employers or clients. We're talking about contracting authorities, the public entity, or the employer who is tendering the contract. And then we talk about tenders or bids, which are the offers submitted by the economic operators, the contractors, the tenderers, the candidate, or the private party taking part in the tender. They send in an offer, and we call that a tender or a bid. So that's usually, when we're talking about construction law, the contractor. And there's a lot of case law on this terminology. What is a contracting authority? What do we consider a public entity? But also on proportionality, on the principles, on the principles, transparency, equal treatment, and so on. European case law, but also national case law. So be aware of that. So who must apply to the rules of procurement? Those are the contracting authorities, the traditional state authorities. So the state, the government, it's not an exact word to be used in this case, but the state and the regional authorities, those are called contracting authorities, but also the bodies governed by public law. So those who have legal personality established for the purpose of meeting needs in general interest and not having an industrial or commercial goal, or those who are financed by the state. So they're not in itself a state authority, but they are financed by the state and they are doing something for the greater good. Then they need to adhere to the rules, apply to the rules of public procurement, or they are subject to management supervision or have an administrative or managerial or supervisory board, which are part of a public body. So a very large group, not just your municipality here or the state itself. It's a large group who must adhere to the principles, the rules, the Procurement Act, procurement laws, etc. So which contracts are covered by procurement law? Because if you are a contracting authority according to the directive and the Procurement Act, it is not that for every pencil you buy, you need to comply with rules of procurement law. No, there are thresholds, European thresholds, which state the amount of money the contract must cover. And if you're if your contract is above those thresholds, then you need to comply with the EU law. But if there's a contract which is below the threshold, there are also principles of the European treaties who apply to the procurement process. And if there's a cross-border interest in certain contracts, then it also might be the case that there's below the threshold that it's covered by procurement law. Oh, that went really quick. So you will be glad that I'm already finished. So in the next video, I will talk more about the procedures, and I will elaborate a bit more on the principles, so you get a better sense of procurement law. And I'll just explain the basics and the nature of procurement law. So hope you enjoyed it, and I'll see you in the next and last video.